I'm looking at a new court decision out of Arizona in a case involving allegations of many sort of hostile and offensive remarks made by one coworker towards another. And it illustrates three different things for us. One is the importance of being mindful of harassment other than sexual harassment as being illegal. Two, an issue around what is and is not included in sexual harassment. And three, the tricky nature of retaliation claims. So the case is in a corrections setting, tough environment, and one employee is alleged by the plaintiff to have made numerous kinds of offensive remarks, many slang references to being homosexual, even though the plaintiff is not homosexual, many relating to the plaintiff's ethnic background, he's Mexican American, and then after the plaintiff complained to the employer, additional comments calling him a snitch and things like that. So plaintiff brings the case, national origin harassment, sexual harassment, retaliation. This is at the summary judgment stage where, as many of you know, a court looks at all the evidence that's been presented, decides whether it should go to a jury or not. Here's what the court did. National origin harassment, the court denies summary judgment to the employer. There's evidence of all these statements being made repeatedly, and that would be a hostile environment based on national origin, which is an illegal form of discrimination. On sexual harassment, the court did grant summary judgment, making these sort of homophobic slurs towards this individual was not based on his gender, which is what Title VII prohibits, is treatment based on one's gender. The court did send the retaliation claim forward, potentially to a jury, saying that the evidence certainly could be construed to show that the coworker, because of the complaints, engaged in this behavior. And any employee's got the right to make complaints without being retaliated against. The court did find that it also noted that the employer's response to the initial complaint arguably wasn't good enough. The plaintiff alleged he identified a number of people who could be interviewed. The employer didn't interview all of them, and that maybe the employer should have done more. It's not to say that an employer always has to interview every potential witness, but certainly shows the importance probably of erring on the side of inclusion. So, we don't know that these things have happened. They will now either the parties will resolve it or it will go to a jury. But it's a case that certainly illustrates a number of different issues. And as we always say, the issue in the workplace to avoid claims and minimize liability is not so much to determine, is it harassment, is it not harassment? You want to address things that are inappropriate and offensive in some way without worrying too much or taking too much time to determine are they illegal or not, because it's easier to solve problems at a smaller stage, even if they're not illegal yet.